morning, bore da, everyone. Welcome to this month's Business Swansea Enterprise Club session on the legalities of running a business. So there are a range of legal requirements for new businesses, and it's imperative that you comply in order to focus on establishing and growing your business. Before we start, can I remind you that the session is recorded. So if you prefer for your face not to be shown, please turn off your camera by clicking the camcorder icon at the top of your screen. This session will also be uploaded onto our YouTube channel. So our guest speakers today are Elis, Phillips and Cathryn Davies from Doulas-Jones Mercer Solicitors in Swansea. And I'm sure we'll all benefit from our legal eagles' experience and knowledge today. No further ado, Elis, Cathryn, over to you.
Okay, so good morning. I'm sure everyone's guessed that I'm Cathryn and this is Elis. I'll just get my slides up, ready to go now. Right, okay. Yeah, so as Stephen has mentioned, we're going to be given a bit of a taster about the legal issues affecting new businesses. I think if we went into every single issue, we'd be here for a long time. But we just want to give a taster, really touch on upon a couple of things that we thought would be useful for people starting a business. And yeah, and like Stephen mentioned, we've sort of cut it down into 3 sections, and we want to try and make it an interactive session. So when we give you the opportunity to ask questions, please feel free to participate.
Thanks very much. Good morning, everyone. As Stephen mentioned, I'm Elis. I'm one of the solicitors in the corporate and commercial team at DJM. And as Kath said, it was quite a tricky one to try and cover everything, but obviously in the time scale it's not possible to do everything in depth, so it's quite a tricky one to try and cover everything in enough depth to give you a flavour, but without spending 4 or 5 hours of your time this morning. But yeah, so the general structure will be to looking at the various different business formats and some of the advantages and disadvantages, and thinking about what type of format suits your business, and then looking how that may develop as your business grows, and how you can protect it from various issues that may arise. So more specifically to a limited company setup, we'll be looking at directors' liability, what those liabilities might be, and how that liability is limited somewhat with regards to setting up a company. We'll look at trying to minimise the risk of disputes and exit strategy, so how it's possible to leave the company sometimes a little easier than the other business formats that we'll look at. And again, briefly looking at some agreements that you may have in place with customers and suppliers. We've already heard that there's quite a range of sort of business people on this call, and you may already be familiar with a lot of these things, but equally there may be some things that perhaps you've overlooked or not familiar with. So things like T's and C's, you may have distribution agreements or supply agreements, that type of thing. So we look at very broadly some of the key terms that you may want to include in there and to look at, and then some of the more practical things which are not necessarily corporate matters, but sort of interplay with running any type of business, whichever format that you have. So obviously HR and employment law affects, I would say, almost every business in some sense, regardless of your size. Intellectual property, which looks at sort of ways you can protect various rights if there's a particular design right or a business name, which we'll cover very broadly, because again it's a huge topic in itself, which we could spend a good deal of time on in its own right. And then GDPR and data security, we've already heard that that's something that that you guys want to hear about, which obviously affects businesses and it's growing as an area which people are sometimes a bit concerned about. And yeah, as we touched upon at the start, there's some upcoming development and tax issues, which I'm sure you've all read about recently in the news, which we will cover very broadly, and give you an idea as to what maybe is to come and how that may impact on businesses. And like Kath said, we've got a Q&A at the end of every mini segment, but that's not to say, if anything comes up, if there's a pressing need for a question, anything you want to ask in the meantime, let us know. And yeah, I'll pass over to Kath now for the first section, and like I said, any questions in the meantime, let us know.
There we go, thank you. So yeah, so start off with business format. So the first one, the one that most businesses start off with, organically, during COVID, there's been a lot of people doing like a side business. So they would start off as a sole trader, which is just a self-employed person running their own business. And it's just an informal arrangement. But of course, the important thing to be aware of is any liability that raises from the business is then personal. Going on from that, you've got a business partnership, and it's 2 or more persons carrying on a business in common with a view to making a profit, and there is no limit to the number of people that can be in a business partnership, and partnerships, they can be entirely informal, or you can set up a limited liability partnership, and that's more similar to a limited company, but we're not going to delve into that today. And then we're also going to cover private limited or incorporated company, which Elis is going to tell us more about, and the advantages of incorporating the business. Okay, so as sole traders, like I said, this is what happens when businesses start organically. They're also known as sole proprietors. They run their own business. Most of the time they work alone. They might have an employee or 2. They might have a lot, but like I said, the liability of the business comes down to themselves. They make all the decisions affecting the business. They're their own boss. That's one big advantage, that they don't have to, they don't have to answer to anybody else, and they're responsible for paying their income tax on the business profits. There's no corporation tax, it's just an income tax. And then when the sole trader retires or dies, the business will finish, although of course the assets of the business could be sold on. The advantages to being a sole trader, it's very informal. You don't have to fill out any specific forms or anything. It's quite quick and a cheap way of starting up the business, and like I said, it's something that can just happen organically. There's no reporting requirements, nothing you've got to put onto company's house. It's very flexible. A lot of the time people choose their own hours to work, and you reap the rewards of the profit that the business makes. But of course there is a flip side to that, in that if you're ill or anything, you lose out on that income. There's an unlimited liability. There's no separate legal entity. There's no succession plan. And it's less prestige, there's less authenticity to it than a limited company. Like I know sometimes banks, if they're lending to a business, I think they'd prefer to see a limited company in some instances, and there's a full responsibility for debts and liabilities. Then you've got partnerships. So I looked this up, and the definition is a formal arrangement by 2 or more parties to manage and operate to business and share as profit. So they share then between them the right to make decisions. They share the business assets, the business profits and losses, and then this unlimited liability is shared between them as well. Again, very informal. There's no specific form that needs to be filled out, and they're all taxed separately. Again, so the advantages is that there's no formalities. There's some scope for succession in the event of death, retirement, especially if you've got a number of partners at different ages. There's no formal reporting requirements, and your affairs are kept private. But again, it's very similar to a sole trader in that the personal liability comes back to you, and there's no separate legal entity, and it is less prestige, but could be a good way of getting the business going. And it's a good way, if there's several of you that have got complementary skills, it's a good way of working together in that sense.
So just moving on then to the private limited company, which is almost, as Kath said, sometimes is a format that people sort of transgress from maybe a sole tradership or a partnership into a more formal limited company format. And again, appreciating that some of you guys may have already gone, skipped the sole tradership or a partnership arrangement and set up a company on the offset, in which case you will be well aware of some of the requirements on you in terms of formalities and some of the filing arrangements. But in terms of the limited company, the biggest or the key benefit is that the company itself is a legal person separate from any of its directors or shareholders. So the company, can enter into contracts on its own, separately to any of the directors. It is a legal being, so to speak. And that means then obviously changes in directorship or shareholding doesn't, spell the end of the company. And we'll come on to in a second how that affects succession and transferability of the business, of the company rather, and what benefits that brings. So as I just mentioned, the company can own things in its own right, properties, equipment, entering into contracts. But the flip side of that is something that no one wants to think about is, litigation or claims. The claim generally will, if the company's entered into the contract and so named, the claim will be brought against the company, which, although no one wants to think about that as a benefit in having this distinct legal person, is that the company tends to be the party to that litigation, and so that's where the protection comes into play. And yeah, so you may have heard the phrase sort of members of the company, which is essentially the shareholders, the people that hold the shares in the company, and essentially the owners. They're all interchangeable phrases that you may have heard. So the members or the owners or the shareholders, they share the profits of the company, if there are profits, of course, and if your company is doing well. And usually that's done by way of dividends, and there's benefit from sort of an accountancy and tax point of view, which is something that I try and stay clear of. We're not tax experts, but something that obviously becomes very relevant in terms of running a company and how dividends play out. And in terms of planning for the future, then it just comes back to the succession point, whereby you can obviously the company can change hands in terms of ownership without that coming to an end. And also we'll cover in a second in a bit more detail in terms of some agreements that you can have between the members or the shareholders to try and avoid any disputes or any confusion or ambiguity as to how company shares are to be dealt with. For example, if someone's retiring or someone dies, a shareholders agreement can go quite a long way to avoiding any disagreement as to what should happen to those shares. And I've got a bit of an interactive scenario for you in a little while as to what might happen in a certain event if your company hasn't set up documentation to deal with shares being disposed of in certain scenarios, and we can maybe get your thoughts on that. Yeah, so in terms of size of companies, obviously it's more of a formal arrangement, but it doesn't necessarily mean it has to be a large or big organisation at all. You can have companies with a sole director, sole shareholder, or you can obviously, everyone knows of some of the massive companies that you deal with huge amounts of employees. So the range really is big, and it doesn't mean to say that a limited company has to be big or small. It does tend to work whichever type of business you want to run. And as Kath said earlier, the treatment from a tax point of view is obviously different, something that we'll cover in the developments and tax issues that have come out of the recent statement, which is obviously corporation tax as opposed to income tax, which we, as I said, we'll have a brief discussion as to how that's changing and how you guys may see that potentially affect your business and tax filings. And yeah, just finally, then you may have seen the how companies are sort of denoted, which is limited or cyfyngedig in Welsh, which just shows what is a limited company and what's not. And yeah, just to follow on the idea of sort of advantages and disadvantages. So generally speaking, our opinion is that there's not a huge amount of disadvantages to having a company. There are some which I'll cover, but generally speaking, it offers more protection than it causes problems, in our opinion. But obviously it won't be suitable for everyone. If you're very new to business and you're just trying your hand and in the infancy of the business, it may not be necessary to set up something quite so formal. But obviously if you are growing or taking things like entering into contracts which have a bit more liability, then as we mentioned, the liability will be limited in the sense that it's the company entering into the contract as opposed to you personally, generally speaking. and obviously limited to the amount of the subscriber shares that were purchased at the outset. So generally there's a limit to the financial liability as well of the company within reason. And something we'll touch upon is the idea of personal guarantees as well, which is something that can cut through that liability point. Something which is often, overlooked is the fact that the business name is protected on Companies House. So you've got to, when setting up the company, you've got to choose a name that isn't already taken. If you manage to find one of them, then obviously that name is then protected, and you can't it can't be stolen from you within reason. And as Kath said as well, there is a view that companies are more or viewed more sort of authentically, or have more prestige, and certainly some of the bigger lenders we've seen that probably tend to deal with limited companies as opposed to a sole tradership. That's not to say an LLP would cause any issues, but certainly some of the more informal arrangements, a company setup would probably be more preferable from their point of view in that sense. Succession, as we've said, you can transfer the shareholding in the company to different parties, and that the company still exists and carries on, although the shareholding changes. The directors can change, the employees can change, but the company lives on, so to speak, and survives any changes in that sense. But the downside of all of that is that there are more, setup processes. Firstly, you need to go through the process of setting a company up with Companies House, which sometimes is daunting to clients, but there is a process that you do vaguely need to know how to set that up. There are obviously then ongoing formalities in terms of accounts that need to be filed, subject to the turnover of the company, I should add. And there are annual filings, so confirmation statements every year, whereby you're essentially confirming the shareholding of the company and any changes, perhaps if you've transferred any shares or anything like that. So that's one of the downsides, is that you do have to keep on top of the filings. And obviously that brings with it sort of a lack of transparency, more transparency, in the sense that you're not able to keep things quite so private with a limited company, given that you can go on to Companies House now and within reason find out quite a lot of information about most limited companies. And as I mentioned earlier, the corporation tax point is something that if you haven't had direct experience in it, can be sometimes a bit daunting and may require professional accountancy advice, which is obviously different to the income tax treatment if you're a sole trader or a partnership. And just to give you a bit of a illustrative example as to how sometimes your business format may change as things develop. Marks and Spencer's is one that we've picked out here, which has shown sort of quite neatly into our presentation how it's moved through the various stages of each type of business. So obviously back in the 1884 sole tradership, moved on to a partnership then, and limited company in the early 1900s, and then slightly later on public limited company, or a PLC, which we won't cover today in any further depth than that, given that I don't think anyone possibly has a PLC here. I'd be very impressed if they do, and if so, we'd be happy to cover it. But generally speaking, most companies obviously stick to the private limited company sort of format. And as I touched upon quite briefly, then this can obviously change as the business develops, as it grows, entering to contracts which are more valuable and the liability increases. And that's when we tend to see sort of sole traderships or partnerships perhaps move on then to a limited company format. So this slide essentially just covers in some depth some of the points that we've already been through, and I understand that Stephen's going to, or the option is there for us to circulate afterwards. So I won't run through each of these with you now, but it covers a lot of the points in terms of the formalities of the different types, the liability, who owns the business, is it the shareholders or is it the sole traders directly? So yeah, feel free to have a look at these slides afterwards and give us a shout if there's anything in particular that you want us to run through. And that brings us to the end of the first segment of the talk, which obviously is more of an introductory sort of setting the scene as to some of the points that we'll discuss in a second. So does anyone have anything you'd like us to cover, or any particular questions? And what I should add in typical lawyer fashion here is that obviously we're happy to address any questions, but it can't sort of constitute legal advice in relation to a specific scenario. But obviously in terms of general queries, happy to talk through anything that we've covered already. Silence.
Is there any questions on the first segment, guys? Oh, I think we can move on to the next one, guys.
Okie dokes.
Fine, no problem at all. That either means we've got a shy group or I've addressed everything.
You've covered everything, Elis, to be fair.
I'm not sure. Maybe we've got a shy group. Fine. So issues affecting, operations. So this will, as I said, this will largely focus on limited companies, given that, as I said, most company entities either sort of progress onto that sort of format at some stage as things develop. And yeah, so we'll look at some of the points affecting companies. So as I said, the liability is limited, but there are obviously responsibilities placed on directors, which are the people, or the people that have day-to-day management of the company. Essentially, they are responsible. The shareholders may not necessarily be directors. The shareholders may be investors who don't have day-to-day running of the company. So it's down to the directors to direct, yeah, basically to make sure that things are running as they should. And yeah, as I said, the directors could be shareholders as well, which happens a lot of the time, but isn't always the case. And so some of those responsibilities, acting in good faith, may sound an obvious one, but obviously being officers of the company, there is a duty on them to act in the best interest of the company, and we've put some sections of the Companies Act here which point to those duties. The other one which sort of ties into that is not making a secret profit. Obviously, the directors have a duty to make sure that there's nothing underhand going on in terms of how the profits are dealt with and divvied up. Some of these things obviously overlap with each other, but skill and diligence, obviously they've got to exercise as much caution as possible and carry things out in a proper way as far as they can, and to avoid conflict of interest. It's probably a phrase that you've heard in business possibly, but it can be relevant, if you're running several businesses sometimes that have overlapping interests and maybe operate in the same sort of arena, similar type of industry, then obviously there are responsibilities to make sure there's no conflict in that sense.
This is something we've got to address quite a lot when there's group of companies,
yeah.
Isn't it? That's something that happens.
Yeah, so there's usually a duty to within board meetings to either declare an interest or any sort of conflict is dealt with at the outset, and you're open and honest about that. So yeah, just following on from that then, so generally speaking, the company is liable for any contract it enters into. We've covered this already. There are scenarios whereby that is cut through, and these are always not to say red flags, but the phrases whereby if you hear any reference to a personal guarantee, then it's certainly something that, as the name suggests, it brings liability on you personally as opposed to the company, and it's something that always should be entered into with caution, and we would say legal advice obtained so that you know exactly what it is that you're entering into. And obviously with that, any personal liability, then it has the potential of any personal assets being brought in, put on the hook, so to speak. So as I say, for that reason, we would always exercise caution and take advice if there's any reference of a PG anyway. And acting in good faith, there's some case law obviously we've referenced there which overlaps with the points I've just covered in terms of not making a secret profit and everything. And one which the courts take fairly seriously as well is wrongful trading, whereby the directors may, if I entered into a contract now knowing that a month down the line I can't pay for that, to pay the bill, and that we're going to be insolvent, well, in that sense, the liability of the directors wouldn't be protected so much behind the veil of the company, because I've entered into something knowing that we have no prospect of paying it. And so that's under the Insolvency Act, something that they obviously take very seriously. And insurance then is something that you will no doubt come across, and insurers will probably offer all types of cover for various things, and there are hundreds of types of cover which are slightly beyond our remit in terms of advising on them, given that they're sort of specialist products that you need FCA approval for. But obviously you can have professional indemnity insurance, building and contents, that type of thing, which may provide some comfort, but it's always a risk benefit analysis in terms of what's the cost of the insurance policy, what does it cover, and obviously it may not be the case that you need every policy under the sun when you're starting your business, and it's a case of weighing up what works for you at that time. And yeah, so in terms of, we've moved on from discussing how companies work generally, and some of the points then in terms of avoiding disputes between maybe shareholders or directors, and exit strategies then. So in terms of the articles of association, if you've set up a limited company already, you will have articles. Every company has to have articles, at least a set of model articles. And model articles, as the name suggests, are sort of template off-the-shelf template articles, whereby there's a company's house can issue you with a very standard set, which works for a lot of companies and brilliant for some, but obviously isn't tailored at all to your business. So it will tell you how board meetings are to be carried out, what the quorum is, which is how many directors need to be present. General meetings, how often they need to be called, what needs to happen at them, how many directors, all sorts of things will be covered in the articles. But as I say, the key thing to think about is whether it covers the company's specific needs. So they may be off-the-shelf articles, but in practice, do they actually deal with the things that your company does? And if not, that in theory, if you're doing things that aren't in line with the articles, then that could lead to some decisions being invalid because they haven't been carried out properly. The flip side of that is that the articles, again, for any company, are available on Companies House. So you can look up now most articles and find out exactly what it says in them. And so if they're not drafted in a proper way or a considerate way, you can find that quite sensitive details about the processes of the company are available publicly, which may not always be wanted or the intended sort of result. Which brings me on to shareholders agreement, which can sort of circumvent some of that, whereby they are not filed on Companies House at all. So it's a private document, whereby you can maybe keep some of the more sensitive bits from the articles and deal with those in the shareholders agreement. So, for example, if we've got shares in the company, and you want to set out how they're to be dealt with if a particular shareholder dies or retires. If there are different types of shares, so you may hear about alphabet shares, you can have ordinary shares, or you can have A, B, C ordinary shares, so you can set out what rights attached to each of those share types. Some might have dividends, some might not. You may only want some types of shares to be able to vote in general meetings, and you may only want some of those shares to attract a distribution of the profits if the company's ever wound up. For example, as well, you may only allow some of those share types to be eligible to buy shares if a shareholder's ever selling. So that comes back to the shareholders agreement point, whereby you can essentially set out how things are to be dealt with, which you may not necessarily want to be in the articles. So yeah, touched upon a potential scenario here. So hoping to have some input here and see what you guys think of this. So if we had a company now whereby I'm a director and a shareholder, I'm looking to retire as a director and maybe move to a warmer country, maybe Australia or somewhere warmer than Swansea is at the minute, but I was still to hold the shares. Can you guys think of, other than the fact that I would obviously be a shareholder the other side of the world, not dealing with the company much and maybe on the beach every day, can you think of anything why that would be an issue in terms of the way the company is run, and how some of the points I've just discussed about the shareholders agreement, how you might sort of address that if you have a shareholders agreement in place at the outset?
I said previously, I think jealousy would be a big issue in this instance.
I'm not off to Australia, by the way. But yeah, any thoughts at all on what issues may come up, or the fact that I'm still holding shares and even though I'm not really involved with the business.
There's one I was thinking of Elis, and this is more around. I'll give an example of one of my previous roles when say we had employees who were operating overseas.
Mm-hmm.
And one of the issues that would come up was, say, for example, there was an issue probably around, their conduct, potentially disciplinary or something like that. We would never hold a hearing or anything overseas. We'd always bring them back into the UK, so we'd be under sort of UK employment law.
Yeah.
So I'm thinking, is that an issue with regards to a shareholder being overseas? With regards to the legalities of that person, I suppose if something was needed to be enforced or anything like that, is that potentially an issue if they're overseas, not actually within the UK, within the legal sort of act?
I think,
is that potentially an issue?
Right, very good question. I think from the point of view of being a shareholder, I can't see that it would cause you an issue in terms of strictly being a shareholder. So if you weren't a director, because obviously in terms of day to day, other than holding the shares, in theory, you're not. If you're not a director, you probably aren't that involved. But a very good question, which came up actually in something that I looked at quite recently, whereby someone was working for a British company, but based, as you just said, based in, I think it was Southeast Asia somewhere. And the question then arose over conduct, and where do you bring those proceedings? Do you bring it's a jurisdiction point, isn't it? Are you in the UK or are you in Southeast Asia? So yeah, I can see why you would always prefer them to be in this country, because that's one argument less to have then, because one defence from their point of view could be, well, I'm not even in the UK, so you can't even bring the claim against me in the UK, so certainly from a director's point of view, or an employee's, yeah, I can see that would potentially be an issue. But as a shareholder, maybe not so much, because I don't think it would matter where you held the shares necessarily, because you wouldn't necessarily be day to day involved in the conduct. But yeah, any other thoughts at all?
Is it actually less of an issue now because of remote working?
It is, and that's something that we've obviously seen a huge increase in with the whole remote working point.
And that's something that, tying it in with the article, sometimes they put it on there, isn't it, that a meeting can be held virtually rather than physically in person and things. So that is something the world is working towards a bit more, isn't it?
Definitely, yeah. We're seeing companies now making that provision, as Kath said, to say that board meetings can take place virtually. It doesn't need to be at the registered address and everything. So I'll give you a bit of a sort of insight. So what I was more getting at strictly from a shareholder's point of view is, I think if this appears now, there we are, we've done our flashy bit of tech where it's appeared at the right time. No, so essentially one of the issues would be that, I'm the other side of the world. I'm not doing anything in terms of the day-to-day role of the business. Maybe Kath is still the shareholder and director here doing all the work. I'm still going to get my, subject to what shares I hold and what the articles say, I'm still going to get my dividends. I can be sat on the beach in Australia doing nothing. I'll still get that. I may not be helping with the running of the company. And so we would want in that scenario some provision to say, look, if you are retiring as a director, you would want something in the shareholders agreement, if you have one, to say that in that scenario, perhaps Kath or the company can buy back the shares from me. So that avoids that problem completely then. Or, if a third party comes along and buys our business for a couple of million quid, whilst I'm still the shareholder, and if we own our shares 50-50, for example, I would still be entitled to 50% of that, even though I've not really done anything recently with the business and I'm completely, estranged from it essentially. So these are some of the things which you can avoid with a shareholders agreement. I'm not saying every single company has to have them, but they should, as things develop, it's As I say, it's not mandatory, but it's something that can really avoid some headaches in that sense.
I think it's quite handy, like as the business grows, you might consider taking on other directors, but you might be a bit risk averse or, you know, not quite sure. But if you set up the shareholders agreement, then you can think about what potential scenarios can arise and how to mitigate the risks, essentially, isn't it?
Yes, definitely. And it's that point of succession as well. You can essentially plan for the future and avoid disputes, but also plan for when things change in terms of personnel, how the company responds to that, instead of having to rewrite things as you go along. So yeah, I touched upon briefly at the start in terms of if you guys are already running businesses, or if you're starting out, you'll obviously come to scenarios where you need to enter some sort of formal agreement with someone. These may be T's and C's which maybe you have on your website perhaps, or you use, or it may be the T's and C's of the company that you're trading with. You may have something like a supply agreement or even a franchise agreement, which is a bit slightly more complex, but there will usually be some formal agreements to govern how you trade with each other. So as lawyers, it causes some a mini heart attack when someone says that, they've been trading with no formal agreement at all. And so that always causes some concern in terms of what are the terms of the agreement? How do you know what the delivery terms are, the payment terms? How long is the agreement? And there can be a scenario where there is an informal agreement verbally, which is very difficult to ascertain what the terms are. So our advice would always be you'd want something in writing. And so, yeah, avoid any sort of uncertainty as far as you can, and try and avoid the lawyers coming in for any claims or costly legal disputes. And normally what you would like to be recorded is some very basic ideas, which of course we can't go into everything, but you may want to know how long this agreement is going on for. Is it a short-term thing, 6 months? Is it to carry on? Can you extend the agreement? What happens when the agreement comes to an end? If you're maybe delivering goods as opposed to services, where is delivery taking place? Do they collect it from your premises? Are you physically delivering to them? Who pays for delivery costs? When are they being delivered? Payment terms, which can be a sticking point. Is that on delivery? If maybe you're paying, if you're buying certain types of goods, or is that maybe within 28 days? And do you have provisions in there which, if there's late payment, what's to happen? Are you charging interest on any late payments or unpaid fees? And then termination. Generally speaking, there needs to be a provision in there which allows the parties to get out of it. Generally, you can't tie parties in indefinitely to an agreement without any scope to leave. But if there is scope to leave, what are the consequences? Is there any knock-on effect? Are there any terms of the agreement which will stick in place even after that's come to an end? Maybe confidentiality, restrictive covenants, possibly, that may still apply even though the agreement's come to an end. So it's really avoiding uncertainty wherever possible, and trying to really make life easier and to avoid any disputes where you can. So again, as promised, a mini sort of Q&A to prompt anything that you've heard that you may have a question about in the meantime, or as I said, anything that you want more information on.
Tara?
Yeah, so I was just going to ask, at the beginning you spoke about insurance. So I've got all the relevant insurances that we think we need. In a partnership, do you need employee insurance?
Well, if you're in, the answer to that is, I suppose, in theory, it's one of them things that, other than maybe car insurance and some other types, which are, mandatory, you don't have to have insurance for everything. So I suppose it's not mandatory. But if you're employing people and employees' liability insurance may be relevant to that. So if you're employing people and you think there's, depending on the type of your business, there is a risk of any liability, then it sometimes could be a good idea. I don't think it's mandatory, but you may well think that is something that you need if you do employ people. And if the number of employees is bigger, then maybe that risk is larger, and so you may think it's definitely needed.
Is it just the two of you? Or?
Yeah, it's just the two of us. We're not going to employ anybody. But if it were to grow, we would take people on freelance, because that's how our sort of thing is set up. So again, in freelance, do you have to have employees insurance then?
Well, that comes into so that comes into a trickier employment law question of, are they an employee or are they a contractor? Which
we're actually going to cover a bit of it later on. Actually, so
I won't take Kath's thunder beforehand now, but so that's a very good question, and I suppose if you're confident that they aren't employees and they're contractors, and there's a whole host of things that you try and do to make sure that they're not seen as employees, if that's what you're trying to achieve, then you'd probably say, well, maybe the risk is less because, you know, they're not an employee, they're a contractor and may fall outside of that. But as I say, the trick with that is that it's not always what you label them in terms of how they determine. So if you say someone's a contractor, fine, but in reality, everything else points to them being an employee. That can, regardless of what you call them, that can treat them as an employee if everyone was to ever dispute it. So
trouble with insurance is until an event happens, you don't realise how crucial it is to have it. You know, you can think to yourself, oh no, I don't want to, you know, it's an extra cost at the end of the day, isn't it? But I think I would really recommend just having a chat with an insurance broker, because I was surprised. I did a bit of research on this and the number of different policies you can have out there, and sometimes they do a combined policy you know, that suits the business and exactly what you do. So depending on the nature of the agreement that you have with the contractors that you're intending on taking on, I think it'd definitely be worth having a chat. There's lots of brokers around Swansea, plenty on Google and things, and I think they're always happy to have their brains picked, from my experience anyway.
Yeah, just to follow on from that, to give an example of how some are more you know, fundamental than the others. You know, you may have, so for example, law firms, obviously professional indemnity insurance is the key one, where and the premiums are always going up, and that's to protect any sort of claims against us as lawyers in the event of any sort of dispute or unhappy clients. Now that is mandatory, but you know, during COVID, now this is just well behind us, thankfully and hopefully. Business interruption insurance, which is obviously on the different end of the spectrum, very, very useful if you had it, but not mandatory as far as I could see, generally speaking. So it's such a wide industry, isn't it, with insurance? Some are a lot more mandatory than the others, and yeah, I suppose in typical lawyer fashion, I'll say it depends on the type of business that you run, the number of employees. But yeah, good question in terms of the contractor situation as well.
Has anyone got any other questions?
I was thinking with you, Roy, do you not only sell your products within the shop, do you sell them online as well? Right?
Mike's off probably.
Oh, is it? I was just going with Roy. I think that he sells not only his products, you know, for walk-in customers, but obviously also online. Mm-hmm. So would his sort of you know, that's what I suppose his customer contract really, you know, that could potentially differ maybe, you know, because he's selling, you know, just from walk-in customers as well as online, because they're two different models really, aren't they? I suppose
require a different set of terms and conditions, and especially if they're then delivered, and you know what happens if the flowers are left by the door because nobody was home. So yeah, you could have terms and conditions and addresses, or you know, number of possibilities.
And yeah, just to build on that then, Steve, a recent example was this exact point, was that this company did sell, you know, I say in person, but also online. And obviously what we did was built in, for example, on the online section of the T's and C's, something dealing with, you know, privacy policy and the cookies, which obviously that only applies if you're shopping online. It doesn't apply to walking into, well, certainly not the cookies anyway. So yeah, that's a good example of how you may want to tailor them slightly to the type of business and how you actually sell them. So yeah, would be definitely a good idea to, if not have a separate set, then make sure that the online ones meet that sort of business need, if you see what I mean.
Well, I suppose a sort of you know, a big thing about the T&Cs as well is what's vital is obviously payment, isn't it, between obviously suppliers and yourself, vice versa, and obviously customers. So, you know, I suppose from your guys' point of view, is, you know, having those T&Cs in place, you know, makes your life a lot easier, that you can actually prove there's been a breach, isn't it? That's the key thing, isn't it? Because that is the fundamentals of running a business, isn't it?
Yes, exactly. And you know, you can tailor the T's and C's to say within reason what you want, you know, and you can build things into, you know, if you have got a 28-day payment period, if it is slightly late, you can build something in to say, well, actually, we're not going to sue you straight away if you're 28 days late. There's a grace period of, say, a month, whereby we liaise, and if you haven't paid it by that stage, then we issue you with a formal notice and this, that, and the other.
What I've seen in practice that works quite well as well is your terms and conditions is your sort of worst case scenario, and you could say, you know, if payment isn't received by this amount, then the contract won't continue, or, you know, something like that. But say if a complaint arises, customer isn't happy, then you can sort of say, look, our T's and C's do say this. However, on this instance, I'm going to work on the good faith, and I'm going to give you a bit of a better deal. You know, it sort of makes the business look good.
Exactly. Yeah. You know, the formal agreements are one thing, but obviously in practice, you know, if there's a commercial decision to say, well, actually, look, there's a really good customer, they are late, but we'll give them a grace period, and that's how things. You can say one thing in the documents, but the things differ on the ground, don't they, in terms of when you run the business day to day. So, yeah, anything else on that area at all? Or?
Just another question on the T's and C's. Obviously, we're happy for some time moving away from hard copy documents to electronic. So in terms of sort of signing off on those, what's sort of your view in terms of what's acceptable in terms of electronic signatures versus sort of hard copy signatures and signing off on that?
Yeah, so I mean, well, in terms of actually signing things, the matter of being, you know, doing it in wet signature or being online, we've seen is not really as much. It's not really an issue. I mean, we use you may have heard of DocuSign, which is a platform where you sign things electronically in summary, and that in itself doesn't cause any issues. The matter of signing online is not necessarily a problem. You can build things into, you know, if you were paying online, for example, by them paying, you put something to say that they agree to their T's and C's, which are set out as a box. Yeah, exactly. So you're not necessarily putting them in the body of the, for example, on the order online, because it might look a bit messy, but you know, by agreeing, you're agreeing to the T's and C's or something. But no, the fact that it's online is not an issue at all. It's just the fact is that you flagged it, these are our T's and C's, and by signing you're agreeing to it. And yeah, we're seeing more of that now.
Roy, you got a question?
I have. It's about shareholders agreements. Being a limited company, I'm obviously registered as director, and I am the only obviously shareholder. So do I need any type of agreement or anything in place?
It depends. Well, at the minute, you would probably have to say, no, you know, if you have no intention ever of having anyone else on board, you know, I appreciate you haven't got a crystal ball and you can't look into the future, but if you're saying, look, I can't see myself ever having someone else on board, I'll only ever be sole director and shareholder, you'd probably say it might not be worth it, because what are you've got complete control over how all the shares are dealt with. If you can transfer to who you want because you've got 100% shareholding, it probably doesn't matter as much. But having said that, if your business does really well and you think, oh, could do with another shareholder on board to maybe start growing or investment on board or whatever, then it probably would be advisable to do that. You know, as I say, if you start issuing different types of shares, you want to make sure that if you want to retain control, for example, only your types of shares have certain rights to them attached. But as I said, you know, without looking to back off the comment, it really depends on what your type of business is, what your views are for the future, and if you've never got any intention of taking out anyone else on board, then possibly might not be worth it, because who are you, you know,
who are you agreeing
with? You know, it's really up to you to do. Yeah. So, but then having said that, you may not think at the minute you're going to take someone else on board, and I suppose at the time that you do, you'd want something in place to provide for that. So yes and no.
Right.
Typical lawyer.
Okay, Ross has got a question.
Yeah, hi, thanks. On company creation, what would you recommend is the right amount of shares to create in the first place if you know you're going to be bringing people on in the future, but not quite sure how many that is going to be?
I don't think there's a right or wrong answer, to be honest. I've seen several companies where sometimes they've got 10 shares, 100 shares, and then sometimes they've got bigger numbers, like 100,000 shares. But of course, it's all divvied up then, isn't it? So if you know you're going to take some on, probably a rounder figure could be better, just from the practicality point, in that, right, you want to give somebody a 10% share. So if you've got 100 shares, you give them 10 shares. You know, but there's no right or wrong answer. Because you can allot more shares at a later date as well. So it's not done and dusted when you do your first allotment of shares on incorporation.
Okay.
Yeah, that's exactly right. You know, you could say there is no. It's literally a figure, really. It doesn't really matter too much. Say you do 100, we see a lot. We see. 10 quite a lot. Say you had 100, and at the minute you're the sole shareholder, you'll obviously hold all 100. If you ever want to take someone else on board, you could just keep the same 100 shares, but then you transfer however many you plan on giving them. Say 10, 20% shareholding, whatever. You could do it that way. Or as Cass said, you can allot more shares, which is to essentially create more shares. So you increase the number of shares from 100 to 200, and
then you can
so
transfer over.
And that is quite fluid. You can buy back shares, which we do a lot of. So the number is like not set in stone at all. No. You can issue more, buy back more, and you can tweak them as you go along, really.
It's a bit like asking how many slices should I cut to my pizza. You know, you can make the pizza bigger. Exactly. But no, I think from a practical point of view, I think you're better off having more shares than less shares, because when you're sharing them out on a percentage basis, well, you've got more to work with if you've got a higher number, but it doesn't really matter. Yeah,
within, it's almost like a numerical thing of what becomes easier for you to deal with. It's easier to divvy up 10 than if you had one, and then you'd have to allot. So whatever works for you, I suppose, isn't it?
Okay, thank you.
Anything else on that, or should we move on to our sort of, I think it's our last segment then.
Information on HR and things.
You happy for us to move on?
Yeah, please do.
Okie doke. So this is again moving on to the practical considerations. This is what's the crux of what we need to do. Human resources is absolutely massive topic, but just thought we'd give you a bit of information. So from April 2020, employers are required to provide employees with a written statement of particulars of employment. So essentially within the Employment Rights Act, Section 1, so it's now written in statute that you've got to provide the employee with basic details. It could be written on the back of a napkin, but no, you've got to provide the employee with details of commencement of employment, rate of pay, intervals in which they're paid, hours and days of work, holiday entitlement, job title, just the basics. That's not the definite list there. There is more. I just wanted to give you a taste there. And if, as an employer, that you fail to provide this, the employee could take you to tribunal, but not as a standalone claim. It would be have to be as a piggyback on, say, an unfair dismissal claim. They could say, well, they're unfairly dismissing me, and also they didn't give me this information on day one, and they could be awarded up to 4 weeks compensation for that. So, it's in law that now you've got to provide those basic details to your employees. And in an ideal world, a new employee would have a contract of employment or written particulars, which includes all these details, and also then a staff handbook if you're intending on taking on lots of employees. It's good to have policies and procedures in place. There's 3 main procedures that are required by law, which is disciplinary and dismissal, grievance, and health and safety policies. But also it's good to have there's lots of different policies you could have, including equal opportunities, maternity, sickness leave of absence, flexible working. It provides transparency to the workplace, and so that everybody knows what the business's stance is on those particular matters. So at the moment we're all aware of the cost of living crisis at the moment. So as many people out there, apparently an estimated 10 million UK workers are considering second jobs. So what can you do as an employer to try and help your employees out? So say if you've got a contract of employment that says you're only to be employed by me, you're not to go anywhere else, could you as an employer look at loosening this? You could speak with your employer and said, look, I know your contract says this, but if you are looking at a second job, I would be happy for you to take it. But if you've got to ask me first, provide details with me, and we'll consider it at that time. And then from a legal point of view, we've got to ensure that the employee is opted out of the 48-hour week under the working time regulations if they are to work over 48 hours. And also, if you look at your business, you could have someone who's signed up to a 30-hour contract and they're looking for more work. Well, I think it's good to try and engage your employees in conversation, because you say, well, actually, with Christmas coming up, I need a driver. Do you mind doing that role? So look at potentially giving more hours to your current employees if that's something that they're looking for. There's other measures that employees are considering. So the obvious one is that they're giving their employees a higher than usual percentage pay increase, which I'm sure everybody would like, or a salary advance, say if they need something before it's due. Another thing employers are doing, making best use of bonus and reward schemes, so that sort of ties into motivation in the workplace as well, trying to get given an incentive to hit certain criteria. Or what some employers are doing, if they can't afford to give the higher than usual pay increase, especially with more costs coming onto the business, they could give a one-off lump sum cost of living payment, but making it very clear that this is just a one-off to try and alleviate the extra costs that are being put upon us with inflation. Or another one is increasing discounts on the goods and services you produce. So maybe Roy could give more of a discount on the flowers he produces or something like that. All right, intellectual property. Elis is going to give some information on this.
Yeah, so very briefly, really, on IP, because I appreciate it's, well, firstly, it's not the most interesting topic, but I do have quite a funny example to give you, so that's something to give some colour. But it's also really quite a vast area of law whereby it generally centres around sort of intangible property rights. So if you've got a company name, which obviously generally protected with Companies House, but if you've got a logo, or if you've got a particular image that you want to trademark, or you've got a particular invention you may want to patent, things like that, tends to come with possibly either a business which is making something quite unusual, or maybe is a bit further down the line in terms of quite advanced and making new innovative products. But yeah, generally speaking, there are various ways of protecting intellectual property rights. As I said, so artistic works or any symbols, inventions that you've made. Generally speaking, the person who creates it, generally speaking, will be entitled to that. Although some contracts of employment can cut into that, whereby the intellectual property rights are essentially taken on by the employer if you've made the invention during the course of your employment, so it may not necessarily be yours to keep. That's quite a common point that we see in contracts. And yeah, so a few points there. So in terms of IP, can have more than one owner, it can belong to people or businesses or companies, and can be sold or transferred. But again, that sort of looks at sort of a bit further down the line as to when things get a bit more complex. And I won't run through each of these here, but the anomaly is almost copyright, which sort of arises automatically. If I write a song tomorrow, probably would be very bad, but I'd have copyright automatically over that without having to register anything or applying, or a film or anything like that. Whereas the other is a bit more formal in the sense of a trademark. or a patent application is a formal thing, and there's time limits, whereas obviously copyright arises automatically, and there's no sort of limit to that time either. Yeah, so just to almost provide a bit of a quite a funny example, which came up recently in terms of if there's any beer drinkers amongst us, that obviously Brewdog are a very popular brand in the last, I would say, 5-10 years maybe. They've become massive. And anyway, so their Punk IPA was, again, if you drink beer, you would know it's like a blue can, which Aldi completely ripped off and did their own version of it. They weren't successfully sued for it, so they obviously got away with it. But almost as a way of getting back, and almost a tongue-in-cheek thing, that Brewdog then made the Yaldi IPA, which is obviously on the screen now, which clearly is Aldi branding. But it was almost like a reverse psychology thing and a way of getting back at them. So yeah, IP is a huge area of law, and there's you guys have probably seen in Aldi all the time brands that you think you don't know how they've got away with ripping off certain brands, but it's a really big area in terms of artistic sort of freedom to do what you want, but not encroaching and taking other people's IP rights. So that's something, again, that you may only come across if you're doing something quite innovative or maybe a bit further down the line in your process of the business.
So yeah, we wanted to give some information on GDPR as well, which a couple of people mentioned they wanted to be aware of. So it's just a legal framework. It sets out the guidelines for the collection and processing of personal information from individuals. And GDPR then, it stands for General Data Protection Regulation. So it's something that's been clamped down on a lot more within the last 5 years. I think with the rise of the internet and everything, something that has now been put into legislation. So as a business, the main thing you need to be aware of is the Information Commissioner's Office, which is the UK's independent body set to uphold information rights, which is funded through registration. And under the data protection regulations, organisations that process personal data, it's mandatory to become a member. So you've got to register and pay your data protection fee. It's quite a small fee, it's about £40 to the ICO, unless you're exempt. So there's certain charities that are exempt from becoming a member, but it is mandatory for a lot of businesses, and they've got quite a handy website. You can just type in ICO to Google, and there is a certain section for SMEs and businesses to break down the information and to make it easier to understand. And oh yeah, they've got a questionnaire where you can answer to find out if you're exempt or not. They've got a good video which I'm going to share here with you now, which explains data protection in 3 minutes.
Hi, my name is Harry, and I'm a case officer in the ICO's Business Advice Services Department. And part of my role is to help operate the Small Business Helpline, which gives advice to organisations that are much like your own. This video is here to talk a little bit about what data protection law is and why it's worth your while to spend just a few moments thinking about it.
Do data protection laws apply to most small organisations?
Whether you have staff or trade by yourself, you're likely to collect the personal data of the people that you come into contact with, whether that be customers, suppliers, or even the people that you employ. For example, you might collect a person's name and address to send out a product to them, or their email to send out a service update or a newsletter. Regardless of the type of personal data that you collect, it's important you use it reasonably and protect it, as this is what ultimately underpins data protection law. The reasons for this should hopefully be quite apparent. If personal data falls into the wrong hands, then people could be harmed. This could be as a result of identity theft, discrimination, or even physical harm. So data protection law explains what should be done to ensure that everybody's personal data is used both properly and fairly. Generally speaking, it applies to all types of workplaces, business ventures, societies, groups, and clubs.
What are the benefits of complying with data protection laws?
So firstly, it helps to build trust, as keeping people's personal data secure is key to getting them to trust the service you offer and more broadly, your business as a whole. This should help to build up both your reputation and your brand. Alongside this, it also makes good economic sense, as adhering to data protection law should end up saving you both time and money. It should help to make sure that you don't incur any unnecessary costs on storage, as well as allowing you to deal with any requests you might receive in a timely manner.
How do I comply?
There's no one-size-fits-all approach to data protection law. Your business is unique, and that's what makes it great. And your approach to data protection law will be unique as well. It's going to end up being much easier than you think, and we're here to help you make any changes you might need to. As a great place to start, it's worth checking out the resources on our Data Protection Hub for small organisations, which contains loads of tools, top tips and bite-sized guidance to help make things more straightforward. Remember, if you ever get stuck, you can feel free to call our helpline and we'll be happy to give you a helping hand.
So that gave a little break from listening to our voices. Yeah, hopefully that was useful. But the main thing when you're trying to address GDPR is that you don't want to have any data breaches. And here's some tips that we've come up with. So if you've got a website, you need to have a cookie policy or a privacy notice in place, which meets the necessary requirements. Yeah, day to day, a lot of us are sending emails, several throughout the day, and it's good to try and make good use of the BCC function, the blind CC. So say if you're sending out a newsletter to several of your customers, if you send it on the normal way of just adding in their addresses, the person who receives it will be able to see the email addresses of all the other people that have it, whereas if you use the blind CC, they won't know who else has had it, and therefore you won't breach the data protection. And also being careful when you're forwarding on emails and attachments as well, sort of looking at what's on the trail of the emails below, and is this person who's going to be receiving the new email, should they be privy to the previous information that's been discussed? And then with receiving emails as well, around this time of year, and I've heard on the radio recently they're trying to take advantage of the cost of living crisis, and they're trying to get people to click on things. So they might be sending you an email to say, oh, we've tried sending you a parcel, and they can make them really realistic these days. So just have a think before you click on any links. They could be trying to put a scam on you. And then data retention then, so if you've got like hard paper copies or copies online, how long and where are they going to be kept? And then staff training as well, with system processes, informing them on how to password protect sensitive material so that it's not leaked. And yeah, we just thought we'd signpost you to the Federation of Small Business on their website there. If you type in FSB free guide to dealing with data, they've got that available on their website, which is aimed at small businesses. Yeah, so there's been lots of developments in tax from the autumn statement last Friday, and the headline ones affecting businesses were the corporation tax is increasing from 19% to 25% from April, several tax threshold freezes until 2028, including income tax, and then for companies then dividend allowances are going to be cut from £2,000 to £1,000 in 2023 to 24, and then down to a further £500 in 2024 to 25. And then if you're in the business of research and development, the expenditure credit has increased from 30% to 20%, but there was a SME additional deduction rate, but that's been reduced. And there's an almost 10% increase in the national living wage to £10.42 per hour for over 2023s, and that's coming in April. And I've put the table there of the other rates, the national living wage rates there. And then, yeah, so I touched on this earlier on, the IR35 rules are changing. So this is the law that is around hiring contractors. So it's basically the rules around if you're taking on a self-employed person, whether or not they're a contractor working for the client, and whether there's somebody who is genuinely self-employed rather than just being a disguised employee. So the status considerations is a whole list if you look online. They include the way the contractor is paid, whether or not they're exclusive to your business or whether they can work for other businesses, and whether or not they own the equipment they've got. There's several elements that are considered in making the decision whether or not they should be self-employed or an employee. So back in April 2021, the legislation changed, which shifted the responsibility for working out the tax status from the contractor to the client. So the business, which is known as the personal service company, they were the ones, the onus was on them to figure that out, but it wasn't very successful, and only 10% of businesses did it right. So from April 2023, they're changing that back so that the onus is going to be on the individual carrying out the work, i.e. the contractor, and they'll be responsible for determining their employment status. And that's it. If you've got any more questions, we've got our details there, so feel free to email us if you've got any specific questions that you'd rather ask over email rather than in front of everyone. But yeah, I hope you found that useful and informative, and it gave you a little taste, and hopefully what we've signposted you towards is good information.
Yeah, it's been great. Thanks very much, both. Has anyone got any questions before we wrap up? We've got about 10 minutes, so if you've got any pressing questions, just put your hands up or just ask out loud. Just let you know, there was the guys referred to human resources employment law. I put a link in the chat about there's a link to our YouTube channel. One of the presentations on there is actually there's actually an employment law solicitor from DJM Solicitors, your colleague Paul Shuttleworth, kindly did a presentation for us, and he went into contracts of employment with in quite a bit of depth. So if that's of interest, have a look on there, and there's a lot of other workshops on there that we've recorded, obviously similar to this as well. So that is a useful resource. I think the interesting one you sort of mentioned about the freelance side of it, because I had a bit of experience with this, when it's quite, it's quite advantageous to a company to do that for a variety of reasons. Obviously, there's obviously sick pay. NI is a big one. NI employer contributions. So it is, and obviously there's a lot of case law, isn't there, around? I think it was Uber case law around that as well. So it seems to be quite a tricky area now. I assume there's got to be some due diligence from the client, as it were, to actually put in place something robust that that really proves and specifies this person is a freelancer, whether it be quite a robust contract for services or whatever. So is there if someone is looking at doing that, is there a lot of resources online which they can look at, or perhaps is it best to get some sort of impartial legal advice? Because it looks like the landscape has changed quite a bit with case law recently.
Yeah, I was well, you mentioned Paul there. Obviously, Paul has forgotten more about employment law than I'll probably ever know. So he knows his stuff inside out. And
yeah, of course.
And I was speaking to him recently about this, and the thing is with contracts is that contracts are great, and you can say what you like in them, but the courts are or the tribunals are more sort of concerned now with the contract can say one thing, but if the position on the ground is different, then that's what's going to take. It doesn't matter what you call them, it's what the actual scenario is. And the example he gave me is, if you're talking of a barber or a hairdresser's, and they're saying, right, they're contractors, they're freelance, they can do what they want. And so, you look at questions like, can they work for other hairdressers? No, they can't. Are they using your branding? Yes, they are. They got your business cards? Are they on your website? Do you pay them? Are they under your insurance? you know, so
are they
that's
using your equipment as well, I suppose?
exactly your equipment, you know, all of this, and you're saying yes, they're in a contractor, but everything else says points towards them being an employee. So it's really tricky in terms of you know, the contract can say one thing, but you need to make sure that the position on the ground is consistent with that, and that comes into the IR35 thing then, which is why this is coming up more and more now, isn't it?
There's a questionnaire on the Gov website actually that if I think if you typed in IR35 on gov.uk, and you can answer a series of questions, and it tells you then whether or not they should be classed as an employee or not, which is really good. Yeah,
no, it's, and you are right though, Steve, the Uber and the Deliveroo, and there's been loads of case law about that, because obviously there was a whole discussion of as to whether they were employees or workers or contractors, and that's what that's exactly the point that came up. They were saying, oh no, they're free to do what they want, but when you looked at the arrangement, you know, they were in title they were free to do what they want, but when you looked at it, they had to take the jobs from Uber if they wanted to get paid when they were sent the jobs. You know, they had to use this, that, and the other in terms of branding, and yeah. So in typical fashion, you've got to look at the circumstances, and it's hard to give a hard and fast rule. But yeah, it's a huge area I think that you're going to see more of.
I think it's worth having. We drew up a contract the other day, and it's worth having it. But the key is to follow what the contract says as well, isn't it?
Definitely.
Okay, great. Is there any questions before we wrap up, everyone? I'll bring it to a close. I don't think there is. So just to wrap up, I'd like to thank both our facilitators today from DJM for agreeing to come and give up their time to do this for us. I'm sure everyone got something really positive out of it. I certainly learned a few new things as well. So thanks everyone, and look forward to seeing you next time.